Welcome everyone. My name's Bradley Needham, and today I'm joined by my colleague Tim Hornby. We're both members of the insurance team at Mills Reeve and deal with a variety of insurance disputes and coverage issues. Just a couple of housekeeping points before we begin. This session's being recorded, and whilst you can see us, we can't see you. And if you have any questions, do just drop them in the chat box function. And if we have time, our colleague and senior legal advisor, Harriet Strevens, will pick these up at the end. If we run out of time and you've left your contact details, we'll also pick up any questions which we don't get to. So our focus today concentrates upon the Court of Appeal's decision in Lonham Group and Scotbeef and what this means going forwards. Now, 10 years on after its inception, the case has provided the first real guidance on the operations of Parts 2 and 3 of the Insurance Act 2015. So we'll be looking at the detailed decision from the Court of Appeal and its implications, without forgetting the importance of three key insurance contractual terms which were referred to throughout the judgment. These were representations, warranties, and condition precedents, all of which played a significant part in the application and interpretation of the law. So at this point, I'll hand over to Tim to get things underway.
Thanks, Bradley, and good morning, everyone. I'm going to start by providing a little context as to why these clauses are an issue at all. To begin with, and as many of you will know, representations and warranties are often confused with one another and used interchangeably, but they are distinct. In the context of an insurance contract, the prospective insured needs to give a fair presentation of the risk when seeking cover. A representation being an assertion as to a fact being true on the date it is made. A warranty is a promise or assurance given by the insured to an insurer. It requires strict compliance, and if untrue, consequences will follow. For the most part, warranties will be express. For example, an insurer requiring its insured to work in a specified way. Condition precedents, on the other hand, are requirements or events that must happen before the contract, or at least certain parts of it, come into effect. These clauses generally fall into one of two categories, as shown on the slide. The insurer's remedy will depend on the policy wording. Where it is not clearly spelt out, common law principles apply, and the insurer may be entitled to decline the claim entirely. So with that context set, Bradley, what happened in the claim?
Thanks, Tim. So D&S Storage had contracted to provide refrigeration and transport services to Scotbeef, who produced and distributed beef-based food products. Now, D&S were members of the Food Storage and Distribution Federation, or FSDF, and incorporated their recommended terms into their contracts, which included a liability limit of £250 per tonne for defective meat. Now, in October 2019, D&S transferred 6 pallets of mouldy and contaminated meat to Scotbeef, which was unfit for human or animal consumption and was consequently destroyed. Scotbeef made a claim for just under £400,000. Now, in response, D&S sought to limit its liability to £25,000 on the basis of the FSDF terms and conditions, which limited the damages to £250 per tonne. Now, D&S argued these terms had been incorporated into its contract with Scotbeef, but Scotbeef disagreed. The parties failed to resolve the dispute, and Scotbeef commenced proceedings against D&S. At the first instance, there was a finding that the FSDF terms had not, in fact, been incorporated into the contract, and as a result, Scotbeef's claim was unlimited.
So that sounds pretty straightforward so far. How did Lonham end up getting involved?
Well, D&S's insolvency followed the first instance decision. This didn't deter Scotbeef, though, from seeking damages, as they added D&S's insurer, the Lonham Group, as a defendant under the Third Party Rights Against Insurers Act 2010. Now, Lonham denied liability, principally claiming that D&S had breached the duty of assured clause, as shown on the slide, by not incorporating the FSDF terms in their contract with Scotbeef. Lonham argued that this was a condition precedent to liability, particularly number 2, giving them the right to decline cover. Scotbeef, perhaps unsurprisingly, disagreed with Lonham's position. The case moved on to the High Court, which was asked to determine, as a preliminary issue, whether D&S had any right of indemnity against Lonham under the policy, which Scotbeef could then enforce. Tim, what did the High Court say?
Well, the High Court found in Scotbeef's favour. Lonham could not rely on the sub-clauses in the duty of assured clause to deny liability for the following reasons. Firstly, all of the sub-clauses, as set out on the slide, needed to be read together rather than as separate clauses. Subclause 1 was held to be a pre-contract declaration of DNS's trading terms at the inception of the policy and could not stand as a warranty or condition precedent under Section 9 of the Insurance Act. Section 9 dictates that a pre-contract representation cannot be converted into a warranty. Subclause 3 was onerous and ambiguous. It failed the transparency requirements of Section 17 of the Act. This required insurers to make sure that policy terms were clear, with disadvantageous clauses brought to the insured's attention. The court found that there had been a misrepresentation by DNS, and so it was necessary for the court to consider the three subclauses in the context of Section 3 and the duty of fair presentation of risk, as well as then the remedies for breach as set out in Section 8 and Schedule 1 of the Act. However, and for reasons unknown, this appears to us to be an error by Lonham. As Lonham had not pleaded entitlement to a remedy under Schedule 1, it could not decline cover for a breach of the duty of fair presentation. So, the court held that Scotbeef could enforce its claim against Lonham. Lonham disagreed and appealed to the Court of Appeal.
So far, so good then for Scotbeef heading into the appeal. Did things get any better for Lonham?
Well, yes, they did. So the Court of Appeal was asked to consider what the correct characterization of the three subclauses were, again, as shown on the screen, and if they were warranties or not. The Court of Appeal held that the first instance judge had erred in treating the three as either being all warranties or all representations. The true formulation of the policy was that subclause 1 dealt with existing contracts at policy inception. Subclause 2, by its wording, was a warranty that dealt with DNS's future business operations during the policy period. This required DNS to trade on agreed terms. Subclause 3 was also a warranty covering future new business relations, ensuring that trading conditions are incorporated into new contracts. So, each of the subclauses dealt with different business scenarios, all requiring DNS to trade on different terms. The only potential liability which was covered under the policy for trading outside of the terms was where DNS had failed to achieve their inclusion into a contract, but were able to show they had taken all reasonable steps to try and do so. The Court of Appeal had noted that DNS was the one who controlled how it conducted its business and the terms that it operated on. For any contract to be covered by the policy, DNS had to comply with subclauses 2 and 3. Unlike subclause 1, this did not involve pre-policy representations.
So after reaching that conclusion on the subclauses, how did the Court of Appeal reach its judgment?
Yeah, so as mentioned, the Court of Appeal decided subclauses 2 and 3 were warranties. They had to be followed during the policy period, and that was regardless of whether the representation in subclause 1. Given the decision in the preliminary trial that the FSDF terms had not been incorporated into the Scotbeef contract, DNS were in breach of the warranties in subclauses 2 and or 3. As these two subclauses were held to be warranties, rather than being governed by Part 2 of the Act, which deals with fair presentation of risk, these needed to be considered under Part 3 of the Act, and in particular, Sections 9 and 10. Section 9 of the Act dictates that a pre-contract representation cannot be converted into a warranty. So, since these subclauses were treated as future warranties, Section 9 did not apply here. The breach of these warranties meant that Lonham had no liability for the loss via the remedy under Section 10 of the Act, that says an insurer has no liability for a loss suffered after a warranty has been breached, but before it is remedied. In this case, the breach of warranty was DNS's failure to incorporate the FSDF terms into the Scotbeef contract. This was never remedied. For example, DNS did not insure Scotbeef then later agreed. Even if it was noted at the time, that was probably unlikely after the contract had already commenced. It was therefore found that Lonham was not liable to indemnify D&S under its policy for Scotbeef's claim.
So after that whistle-stop look at the case, the question is, what does this mean for insurers and insureds going forwards? Tim, care to share our thoughts on this?
Of course. So, off the back of that decision, we imagine that insurers are still likely to impose terms on their insureds that require them to trade in a certain manner. For example, including the implementation of industry standard terms. It will remain in both the insurer and insured's interest to contract on terms that limit liability. This is particularly the case in certain industries, such as logistics and storage warehousing, as operated by D&S here. The decision also underscores the need for insurers to draft their policies with precision and clarity, ensuring that all terms are properly characterized and communicated to the insured to avoid potential disputes and liabilities. The key takeaway for insurers is the importance of the terms of the insurance policy clearly distinguishing between representations and warranties. In particular, to avoid the potential for representations being inadvertently converted into warranties by the drafting. This is especially important where those terms control an insured's potential liability and therefore in turn an insurer's potential liability as well. Likewise, policyholders must make sure that they understand and adhere to those terms to ensure they are entitled to an indemnity. If insurers do not understand the meaning of clauses in their policies, they should absolutely discuss this with their brokers.
Thanks, Tim. Harriet, at this point, do we have any questions? I think we seem to have lost Harriet for an unknown reason. Not sure what's happened there. Probably an IT glitch.
No, not at all. It's entirely my fault for switching it off. So I'll start from where I started a moment ago. Yes. Do we know whether the Court of Appeal gave any consideration to the transparency requirements under Part 5 of the Act?
I can field that. Thanks, Harriet. The short answer is yes, they did, as this was something that the High Court had considered. The appeal court held that the High Court had mistakenly found that the transparency requirements in Section 17 of the Act were not met. This was based on the incorrect assumption that Sections 2 and 3 applied to subclauses 2 and 3. However, those subclauses were warranties, not representations, so Section 16.1 didn't apply.
And just as a matter of interest, can you remind us what 16.1 says?
Well, in a nutshell, the main question was whether the policy terms contracted out the limitation on remedies contained in Sections 10 and 11 of the Act. Now, as Tim's mentioned, in this case, there was no such attempt. Subclauses 2 and 3 didn't put D&S in a worse position than they would have been under the Act.
It's interesting, isn't it? Because a second question posed is this. You say that it's important for insurers to be able to clearly distinguish between representations and circumstances where they could be inadvertently treated as warranties. Now, one asks, how is this to be avoided in practice? You only know what you know. You don't know what you don't know. Is there a quick fix or at least extra precautions which could be put in place?
I think it's fair to say that the issues only really arise down the line and essentially once it's too late. It only really becomes an issue if an insured finds themselves potentially falling foul of policy terms, or conversely, an insurer is unable to rely on a term as they intended. I don't think there's a one-off answer to this, and it requires careful thought, or food for thought, as I'd say. Checks and balances and serious consideration of the purpose of the clauses for insurers. There needs to be a true understanding of what the clause is trying to achieve and what risk it is mitigating. In particular through clear labelling, although labels never guarantee interpretation, and equally clear separation of clauses, saying that if there's no intention for them to be complied with as one. There needs to be clear dialogue of understanding between, or rather an understanding between the contracting parties from the outset. So for the brokers on this webinar, and as they'll hopefully all be aware, their obligations when advising on a policy to an insured extend to explaining the impact of important and onerous terms, particularly those that go to the heart of whether the policy will respond so insureds can clearly understand them. Now, we're not saying that every warranty or representation in a policy is onerous, as ultimately each policy is different, but clearly explaining the intention and impact of warranties and representations in a policy to an insured is important. Now, an internal note by a broker recording that conversation could go a long way in persuading an insurer later on down the line of the insured's understanding of the terms from the outset and the difference between the two. It may be even that the broker, if there's any doubt, engages with the insurer for clarification of the intention of the wording, with a note and email being retained, of course. Now, from a practical perspective, we appreciate that is easier said than done, but clear dialogue between insureds, brokers and insurers over any unclear and ambiguous terms in the policy needs to be had before the policy starts, because by doing this, there's hopefully a better chance of avoiding a dispute arising about any unclear terms in a policy later on down the line.
I mean, it seems to me that the penalties are quite ferocious when you don't understand. And of course, that makes it very difficult, doesn't it? When at the moment of inception of the risk being taken on, everybody is perfectly happy with what they're looking at, and there doesn't appear to be a problem later on down the line. I mean, that's a very extensive answer you've given, and thank you very much indeed for that. We are running out of time now, so I'm going to pass the baton back to you, if I might, to wrap up.
Thanks, Harriet, and thank you everyone for joining us this morning. We hope you found this session useful. You'll receive a copy of the slide deck following the presentation and a questionnaire, which we'd be really grateful if you could answer. Your views are valuable to us, so please do let us know what topics you'd like us to cover next. And if your question was posted in the chat box, but we haven't had a chance to answer it, we'll follow up with you directly, assuming we've got your contact details. Otherwise, we're now going to break for the summer period, and our next cover talk, hosted by Helen Tilley and Pete Maloney, will be on the 25th of September, when they'll be looking at fraudulent first-party insurance claims. So please keep an eye out for the invite, which will be sent over the next few weeks. We hope that you'll be able to join us on that occasion, and in the meantime, we wish you a good rest of the day. Thank you, everyone.